Olcay. I'm a member of the international law group here at Glasgow. The theme of this panel is travel politics and the ICJ, and it's quite nice fitting to be talking about this theme today, as it was earlier mentioned. The court is dealing with so many politically sensitive cases, and in general, it's operating in a sort of heightened, in an environment of heightened global power politics. We have 4 speakers lined up on this panel, and this is the first panel of the day. Maybe it's helpful to quickly go through the format. We have about 2 hours for this panel, and each speaker will have 15 minutes for their presentation. Once all 4 presentations are complete, we'll open the floor for questions and discussion. The first speaker today is Professor Andreas. He is Chair of International Law and Director of the Mainz International Arbitration Center at Johannes Gutenberg-Universit of Mainz. He has been a member of several committees and study groups of the International Law Association and has experience also in advising states on various matters of international law. He'll be talking to us today about the normative effects of ICJ decisions or advisory opinions, even when they are not complied with or respected, which will follow on nicely from the keynote lecture. Can I please ask you to come over here?
Yeah, sure. Yeah. Thank you very much. Yeah, thank you for the invitation to be at this conference. Topic very close to my heart. This is my first time in Glasgow. I have to admit, I'm still kind of easing in the Glasgow accent. Yes, I'm at about 55% understanding, and maybe at the end of the conference, I'm closer to 100%. All right. So, as was mentioned, I will be talking about a topic that I think follows very nicely to Alison's keynote speech. And also, it will be, Alison, if you permit, also a bit of a glass half full presentation in a way. And also, as you will see, I will follow the tradition in proceedings before international courts and tribunals, and I haven't written out a speech, but I try my best to make it entertaining nonetheless. Okay, so let's start. An ICJ judgment constitutes an international legal obligation. It binds the disputing party states as any other rule of international law does. Yet if a powerful state disregards a decision or an opinion of the World Court, what, if anything, remains? In short, what does the ICJ have to offer when faced with world power? When stripped, not de jure, but de facto, of the normative command of its decisions, which contributions, if any, can the court still make to the integrity of the international legal order? And what about advisory opinions that are, as we learned, even in the court's own words, as such, not binding? This will be an inquiry at the margins of international. Will not deny the doctrinal structure of international law, or the bindingness inter partes of international court decisions, or advocate for the formal legal bindingness of advisory opinions. Rather, I want to ask what happens if powerful states ignore ICJ rules. They marginalize them, both decisions and advisory opinions. First of all, this beckons the question, what are powerful states? In the present context, I should give it a relative and an absolute aspect. First, the relative aspect means states more powerful, militarily, economically, or otherwise politically, than the opposing party in a dispute. 2, powerful states are those that can withstand, without significant consequences, judicial remedies and attempts to enforce them. So that's exactly the question, what remains then? In the following, I will contend that if such powerful states shun ICJ judgments and or opinions, if the formal legal effects of its decisions are cast to the side, what remains, in fact, is far from nothing. Rather, I submit that one can identify at least a minimum of 4 normative effects, potentially reinforcing each other. Call them normalizing, stabilizing, anchoring, and remedying they arguably offer a minimum review to powerful states' marginalization of ICJ jurisprudence. These four minimal effects that arguably remain despite powerful states' resistance can be categorized into long-term, medium, and short-term effects. Normalizing, stabilizing, and anchoring are primarily long and medium-term effects, but remedying materializes within a shorter time span. These effects arguably characterize interstate adjudication more generally, but I focus here on the ICJ and will thus, in the following, exclusively refer to the court and its jurisprudence. ICJ decisions first entail normalizing effects. They translate law into a language that permits its resolution. As Bourdieu explains, law gives form to the chaos of human interaction. It provides a common language, and such homologation, makes the incomparable comparable, and thus makes conflicts resolvable. This is the promise of ICJ adjudication, resolving a conflict through a decision by a neutral, impartial, and independent arbiter based on international legal norms. The provisional measures order in the Temple of Pre-Verha interpretation proceedings is a good example. On the brink of war between Thailand and Cambodia, over the territory surrounding the temple, the court ordered proprio motu, a demilitarized zone around the temple area. Both sides followed suit, and a serious armed conflict was prevented at the time. Even more importantly, international court decisions normalized by setting a viewpoint on the relationship between the normal and the exceptional in international affairs. The ICJ's first contentious case demonstrates this aptly. In the Corfu Channel case, the court dismisses the United Kingdom's great power move to sweep the channel of sea mines without consent. If accepted, such a policy of force, the court held, quote, would be reserved for the most powerful states, thereby perverting the administration of international justice. ICJ dispute settlement thus rejects exceptionalism and insists that international law operates from the rule to the exception, and not vice versa. Second and third, ICJ rulings entail stabilizing and anchoring effects, ascertaining and developing international law, and reducing the scope of plausible disagreement over how to interpret and apply an international legal norm. As regards the stabilizing effect, the court may positively state the specific content and requirements of an international legal rule or principle, or it may negatively determine that the norm in question does not or not yet exist in international law, or that it's not applicable in the present. For example, in its climate change opinion of 23 July this year, the court did not only confirm the customary status of prevention principle, as it had done already before from Corfu Channel to Gulf Mills. It also, for the first time, established this customary norm's characters as an obligation ergo omnes. With respect to negative determination, for example, in Jadhav, the ICJ did, quote, not consider that an objection based on the clean hands doctrine may by itself grant an application based on a valid title of jurisdiction divisible. Similarly, again, in climate change, the unanimous court rejected arguments submitted by participants that the climate treaties constituted lega specialis vis-a-vis other rules and principles of international environmental and environment law, especially rules of customary, such as principle of prevention. Such determinations by the World Court may further entail what it refers anchored. They shift the argumentative burden in future legal argumentation, inside and outside the court. Once the ICJ has stated the requirements of an international legal norm, or that it exists in the first place, the otherwise wider scope of plausible disagreement shrinks, and the legal discourse thereafter necessarily revolves around such determination. Hardly any state arguing that it acted in self-defense may ignore ICJ jurisprudence on what constitutes an armed attack. Similarly, after the opinion of 23 July 2025, states will hardly get around to explaining at least in detail why they think Article 2, Paragraph 1 of the Paris Agreement does not establish the obligation to limit the global average temperature increase to 1.5 degrees Celsius. This is all very well, one might counter, but oftentimes such normalizing, stabilizing, and anchoring do not stop or much bother a powerful state if it chooses to ignore an ICJ. Arguably among the most painful examples to this effect appears to be what Alison also referred to, the ICJ's provisional measures order in allegations of genocide, 16 March 2020. The court, by a 13-2 majority, ordered the Russian Federation to, again, quote, suspend the military operations that had commenced on 24 February 2022 in the territory of Ukraine, end of quote. However, 3.5 years later, as we all know, Russia's aggression against Ukraine continues with merciless force. The court itself, in addition, in its preliminary objections judgment of 2 February 2024, found that it eventually had no jurisdiction to give judgment on most of Ukraine's claims. And yet, I submit that the 2022 order illustrates the fourth, that I call remedying effect, that ICJ rulings offer in review of raw power. We'd like to highlight two of its aspects. To start with, international court proceedings provide the weaker side to a dispute with a forum to state its claims, present the facts, tell their side of the story, and to point to the potential injustice leveled against it. In allegations of genocide, Ukraine thus could speak law to power, even with Russia not participating in the proceedings as the provisional measures state. Most importantly, it could build a counter-narrative to the cynical pretext of aggression before an important public forum. Other examples pertain to advisory opinions, are well suited to give a voice to stakeholders otherwise not heard or duly ignored in international relations. Examples include Chagos, the OPT, and also the climate change advisory proceedings, among many others. Beyond such expressivist aspects, however, and that's the second point, essentially, ICJ rulings may entail motivational effects on the behavior of third states. Again, the provisional measures ordering allegations of genocide, to my mind, demonstrates how such mobilization can form a central aspect of the remedying effect. After several years of war in Ukraine, and faced with the tough negotiations for a ceasefire and peace agreement, one may forget the situation that Ukraine found itself in during the first weeks of the war. Standing alone, with Russian troops marching on Kiev, and with Western states, my home country Germany in particular, dragging their feet to robustly support Ukraine with financial and military aid. Ukraine submitted the application in the case only 3 days after the invasion, when many thought that full Russian conquest of Ukraine within months, if not weeks, was a fait accompli. To states both friendly and neutral, the application signaled the willingness to submit to peaceful dispute settlement, to resolve the dispute by law instead of force, and to tackle the Russian pretext for going to war head on, making them the very center of Ukrainian claims under the Genocide Convention. Even though eventually the court dismissed jurisdiction to pronounce on these matters in its February 24 preliminary objections judgment, its 13-2 order of March 2022 arguably had the said motivational effects at the beginning of the war. The order placed the international legal obligation on Russia to suspend its military operation in Ukraine. Regardless the substance, or lack thereof, of Russia's pretextual arguments of self-defense, etc. This clarified without a doubt that any continuation of the war breached international law, and thereby clarified who breached the law and who summoned it to its defense. I submit that it is likely that this constituted an important argument in getting especially European states, including Germany, on board to significantly step up their support for Ukraine in delivering weapons, military equipment, and financial aid. The more than 30 applications for intervention on the side of Ukraine, starting in spring 2022, attest to this in my opinion. The states applying for intervention have been shouldering the vast majority of financial, military, and intelligence support for Ukraine throughout 3.5 months of the war. Allow me to conclude. Even in the face of powerful state sidelining, ICJ rulings nonetheless arguably entail four minimal effects. I submit that these long, medium, and short-term effects potentially reinforce each other. Normalizing may enhance stabilizing, which fosters anchoring. Anchoring, such as stating the unequivocal obligation to uphold the fighting in Ukraine, may lead to remedy, which in turn feeds back in the long run into the normalizing effect. All of this, of course, describes potential and is by no means automatic. Clearly, in a world of increasingly raw power, those four effects constitute no more than a minimum, but an important minimum nonetheless. Thank you very much for your attention.
Thank you very much, Andreas, also for being prepared so diligently.
Our second speaker, thank you. Our second speaker is Walter Arevalo Ramirez, who is full professor of public international law at the University of Rosario in Colombia. He is also president of the Colombian Academy of International Law, and he's been counsel and party for states and international organizations in proceedings before various international tribunals. And very fittingly, he'll be talking to us today about Latin America and the ICJ. Yep.
Well, good morning, everyone. Thank you very much. I'm really pleased to be here in Glasgow. It's my first time in Scotland. It was a very long trip, so I hope I can resist 15 minutes without falling asleep because my schedule is absolutely crazy today. I think that Andreas' presentation has given me a lot of food for thought because his normalizing effects and these effects that he has said that are applicable to powerful states, I think that are also very applicable to very non-powerful states as ours, and that we need those effects to entertain this discussion. I will be speaking about the ICJ in Latin America, and I will try to brainstorm along the abstracts that you have read from our panel, which are very interesting. I will try to engage in three main topics of ideas, which is talking about my perception of the Latin American case law before the ICJ, my feelings about it, and some ideas that I have come through after the work of assisting my state from the Diplomatic Academy, listening to the questions that the politicians, the councils, the international councils have posed to the academia. Also talk about how there is a persistent tendency in Latin America about resistance, backlash, and non-appearance before the court, and how there is a balancing act between the region and its alleged intention to solve disputes by international law, but also when the judgment comes, you see states posing resistance and see states behaving in ways different to which you would expect. And finally, setting a question that I would like to all of you help me find the answer, which is really Latin America going to the ICJ to solve cases, but at the end, not solving their disputes and just entertain in a never-ending succession of cases in which they find judgments and judgments and judgments. The politicians get angry, and you never solve the final conflict. I think this is not working. The next one. It's not changing. Maybe not. No, it's not.
Sorry, you can do some help?
I can tell you to pass the slide, maybe. Let's...
Again?
Okay, perfect. Thank you. So regarding the first point in the case law of the ICJ, I want to start with an anecdote, which is that in my time in The Hague as an academician, but also assisting the embassy for a while, and in the very early stages of the ICJ Nicaragua against Colombia cases, 2012, everywhere you go, a diplomatic meeting, everywhere you go, a meeting with councils, everywhere you go, a classroom, everybody said, Nicaragua is the best client of the court. And if you met a Nicaraguan official, he said, yes, we are. So it's very interesting to see how the states reflect on their position before the court. And this made me think that there's still plenty to write and to analyze about how the region behaves in the court. And when you realize what you can try to establish is that statistically is the second region with the most cases and is the second region with the largest caseload. It has 19 to 22, depending if you count the pending cases in the caseload, and 11 countries of the region, a region of 30 countries, have been applicant before the court. So the presence is really important. But when you look at it, most of the cases are about delimitation and territorial issues. So it's complicated for the region to say that it has been all over the court, in all over the topics, because most of the issues are still relevant to the uti possidetis juris and the configuration of the region. So when you look at the case law, you see that only a few cases are about state responsibility and other topics, but the country is still being engaged in this, something that many of the regions have already adverted, which is delimitation. In this sense, I think the biggest problem or the most realistic point that you can take about the participation of the region before the ICJ is that the participation is not really about believing that the court is going to solve their problems. It's not a participation that is based on a political regional idea that the court is the final step to solve a political issue. I think, and I hope I'm not being too realistic or pessimistic, is that the issue is that we have the broadest competence clause before the ICJ. When you look at the Pact of Bogota and you look at Article 31 and Article 32, and you try to compare it with other regions, you see that it's just the broadest clause. It is a clause that says you can sue your neighbor for anything. You can entertain a case for any issue related treaty interpretation, any issue regarding international law, and any issue about reparations. And this very big, very interesting clause that allows us to sue everyone is not backed with a political system, is not backed with a political discourse of effectiveness, is not backed with a modern political discourse on peace and security that implies that once we go to court, we have solved the issue and we can really believe that international law has solved something. So I think there is a realistic point to make about that. But also, I think there is a tendency that is not very good for the region, which is that most of the litigations is Latam to Latam. Is us against us. And it's also because the issues are always about delimitation. We're starting to overcome this. If you go to the docket of the court, you'll see that the only case before Nicaragua against Germany, which implies other states, is the famous Liechtenstein case, the Notamon case. And I think that's also part of the issue with the region. The region needs to engage in more global issues. The region needs to contribute to more global discourses. And I think the participation in the recent cases involving Israel, Palestine, and the involvement in advisory opinions is helping the region to leave this neighborhood idea of international law. And I think that's a very good point for a very swift analysis of the case law of the region. I think that also there needs to be a movement that tries to re-engage in the real contributions of the court of the region before the court. And I think that there is a set of cases that everybody remembers, and that there's a set of cases that everybody says they're very important from the region to the international law. The asylum cases, the Notamon case, military and paramilitary activities, and Avoidance, which many say have grounded principles of international law and have created an idea that the interpretation of the region to international law contributes to the development of international law. But it's very important to start to value and to analyze the new cases of the region and how they really contribute to international law. I would just like to point to some of them. The recent litigations regarding environmental reparations and these cases in Central America have created new standards of environmental reparation. And the litigation regarding the extended continental shelf and how you can really fight misleading interpretations of customary international law, in the case Nicaragua against Colombia, and entertain your own proper interpretation of what are the boundaries of customary international law, are wonderful cases that people still need to learn about and need to start to value, because those are in my opinion, the new leading cases of the region and their contribution to international law. I would like to add that there is a fascinating case in which I think the best Latin American case before the ICJ is not a Latin American case. If you go to the Burkina Faso Mali case, you'll see a love letter from the ICJ to the region. You see a paragraph in which the court says, this region, Latin America, in their independence, created an idea, uti possidetis juris. And this idea has solved and will solve many issues from today to on by applying it to other regions, to applying it to Serbia, applying it to the African decolonization. So I think that the ICJ has, in many ways, also recognized the contribution from Latin America in their case law. And I really recommend that you read paragraph 20 of the Burkina Faso Mali, because it's very interesting to see how they say Latin America created a universal principle of international law for all of us to use. Now, I would like to go to the second issue, and it's resistance, non-appearance, and the position of the region when bad judgments come and difficult situations appear from the ICJ. I think there is several difficulties in Latin America, and I guess that happens in every other region, in which how we entertain the cases and how we entertain litigation. Another anecdote is when in a meeting between the Diplomatic Academy of Colombia and the board of ex-ministries and ex-presidents, an ex-ministry of Foreign Affairs told me, you have to do everything you can and that is in your power to avoid these people to stay in the ICJ, because the Chinese judge is biased against Colombia, and she will do everything to get Nicaragua to win because they want to make an interoceanic channel. How can you create a logical framework of international law when politicians are understanding the jurisdiction this way? It's very hard and very complex to explain them that, for example, in her own opinions, in her own separate opinions, Judge Shiyue was actually the one that mostly understood and better understood the arguments of Colombia. But that evidence doesn't work with politicians. And I think that the ICJ litigation in Latin America is still very overcome and is still captured by what politicians think about the court instead of what lawyers can understand about the court. This led, and has led in many other countries, to the idea that non-appearance of backlash is a possibility, and that whatever happens in the court may stay in the court, you might still have a judgment, but if the politician said the next better step is to not appear, the next better step is to not implement the judgment, you can do it. I think that also shows the climate between the region and the court, and I think that has to be overcome by more political efforts, despite all the legality and despite of the legal discourse that is very relevant in the region. In the same sense, I think that there is a very complex issue today with the constitutions of Latin America that shows another difficult relations between our region and the court. Since most of the litigation is based on delimitation and is mostly based on uti possidetis juris, the Latin American countries have started to create a tendency which is very difficult to analyze, because you would believe that it is good for the court, but at the end you see that it is mischievous and is also a tricky position. You see countries constitutionalizing the ICJ judgments when they win, and they put in their constitutions the ones that are good, but they avoid and don't write on the constitutions the ones that are bad. In the case of Honduras, for example, once they started to see that Nicaragua was suing them, they constitutionalized the award of the King of Spain judgments, just to say, okay, those are our boundaries. When you see the Nicaragua constitution, Nicaragua has very recently made amendments for the constitutions to put the 2007 and the 2012 judgments in which they believe they won against Honduras, against Colombia, but they neglect and they don't constitutionalize any other judgments in which they could have lost. And in the case of Colombia, you also see the same behavior. Colombia, despite we absolutely won the last cases and the last stages of our case, we still say that the 2012 judgment is inapplicable because our constitution, as all of the other in the region, embrace the original uti possidetis juris, and if the 2012 judgment changes it, we cannot apply it. So these uses of constitutional law to do a cherry picking about the good cases is a misbehavior and something that shows that the region is not being honest with the jurisdiction and is not contributing to the full implementation of international law. And finally, I would like to reflect on an idea, and of course, we can, in the question sections or in the coffee section, we can speak more about those issues. And I think that the region is starting to realize, or there is a tendency in the region to believe that the ICJ is bringing us a lot of cases, is bringing us a lot of judgments, but it's not really solving our problems. And I call that the Hotel California effect. You might remember this song by the Eagles, which says that you can check out any time you want, but you can never leave. I think that Colombia and many other countries believe that this is what happens with the jurisdiction, that you can end up a case, that you can have a judgment, a final merits judgment, but that doesn't imply that the litigation will continue or that the political issues will continue. And I see this issue in many levels. For example, recently, the politicians in Colombia and the Ministry of Foreign Affairs is entertaining the idea that we should ratify UNCLOS. Non-ratifying UNCLOS was a very hard issue in our previous cases because it implied a big debate about the applicable law, about customary international law regarding the continental shelf. Colombia is starting to try to ratify UNCLOS, maybe after a nightmare. But the politicians say, whatever you do, whatever you analyze, make sure that ratifying UNCLOS doesn't going back to the ICJ, because we don't want any more cases. And this shows that there is fear about this jurisdiction and that is not really solving the problems. I think this is a tendency that starts very early. When you look at the asylum cases, the Haya cases, you see that there were 3 judgments. And at the end, they really never finished the issue. The issue was solved at the end by political exchange, by reinterpreting the case law, but it never got to a final decision. Also, in the obligation to negotiate an access to the Pacific Ocean between Bolivia and Chile, you see how, thanks to these broad competence clauses, the states aim to have a meaningful statement from the court, but they are not really aiming to solve the whole issue in the court, and that they understand that maybe these meaningful statements can be used in a next political step. And also, in the Nicaragua against Colombia cases, well, we start to believe that if we can be sued 1, 2, 3 times, we can be sued many more times. And the issue with that is that for the applicants, sometimes they are using the court not as their venue to finally solve issues, but to start more improper and sometimes more lawful litigation. So I think that the region has to reflect on itself and has to reflect on how they use the court. And if they really want to create an idea that this court is just another political tool that you can exploit, or is a real place to solve continental issues. I hope to speak more about these topics with you along these 2 days, and thank you very much.
Thank you very much for that rich presentation. We'll now turn from Latin America to China. Next up is Shiyue Lu, who is a PhD candidate at the Faculty of Law of the University of Lisbon, where she is also an assistant researcher at the Lisbon Public Law Research Center. She also serves as the rapporteur for the Portuguese branch of the International Law Association. Where is yours?
Okay. Good morning, everyone. My name is Shiyue Lu from the Lisbon Public Law Research Center. And today I'm going to present the great power involvement in the ICJ. And already you can tell, I will particularly focus the case of China. Thank you. So this work forms part of my doctoral research project, China's Pathway Towards the Peaceful Settlement of International Disputes, and in which I examined the asymmetrical approach of China towards different kind of dispute settlement mechanisms like the WTO or the UNCLOS and also the ICJ. And when we talk about great power, and there's different schools of thought have different formulas, but as Philip Jessup just remarked, great power have power because they are great. And maybe just last week, British media outlets, for example, BBC or The Guardian, covered China's military parade, an event which showcased this kind of great power mindset. Okay, then at the outset, I would like to distinguish between two modes of involvement. First is the direct one, and the state appears as either applicant or respondent. Also, most importantly, state takes part in the formal proceedings of the adjudication. And in ICJ case, China have no case like this. And second is the indirect mode. Under this category, I made 4 subcategories. First, right to intervene. And second, non-appearance strategy. The particular case is the South China case. Although China did not participate in the formal proceedings, but it defends its position beyond the formal proceedings, sending irregular communications to the arbitral tribunal. And the third is to participate in the advisory proceedings, and the last one is the judicial representation. If we look at the history of China's interaction with the ICJ, the earliest contact can be traced back to the Republic of China, and which once appeared as a respondent before the PCIJ, and even once made the declaration under Article 36, paragraph 2 of the ICJ statute. And also, until the People's Republic of China regained its seat at the United Nations into 1971, and China immediately rejected this declaration made by the Republic of China. And also, China maintained disengaged from the court for more than a decade until the judge Ni Zhengyu was elected in 1984. And since then, China has maintained a continuous judicial representation on the ICJ bench. And since 2010, and China has been more active in participating in advisory opinions. And until date, there are 5 instances of such participation: the Kosovo, the Chagos Archipelago, and the 2 proceedings of the occupied Palestine territory, and also climate change. And now let's look at in these 2 charters, I try to quantify China's participation in advisory opinions. And particularly in these 5 cases, all the 5 permanent members of the Security Council took part in the proceedings. And we can tell China's written statement compared to others that were relatively shorter, but also indicate a certain progression in its written submissions. If we see the pages, the length of its written submit is more and more. And then China also participated in the oral proceedings in 4 cases. And also in 3 of them, Chinese judge Shi Hanqing issued her own opinion alongside the court's advisory opinions. So in my research, I mainly focus on these 3 sources: China's submissions and ICJ's opinions and the Chinese judge's opinion, to find out what is the position of China and what is the major convergence and divergence of legal opinions. And first, if we look at the Kosovo case and the Chagos Archipelago case, actually China's written submissions were very brief, almost like a political, like a diplomatic statement. And also the issues China addressed in these submissions, and it's those issues could touch upon its core interests. So for example, in the Kosovo case, China very much opposed to the remedy self-determination, because this can implicitly touch upon its core interest regarding Xinjiang and Taiwan. And in the Chagos Archipelago case, actually China expressed, I would say, full empathy towards Mauritius' position, but it can't convey its support in a very cautious way, because it might fear that this case is touching upon the bilateral territorial dispute. And according to China's long-standing practice, this kind of dispute should be settled by state consent. And to China's relief, and the court confirmed that this question is not about territorial dispute, it's about decolonization. And also Judge Shi's declaration, she said she was in full agreement with the court and further addressed this non-circumvention principles. That means advisory proceedings could not bypass states' consent in solving dispute. And now let's turn to see quick look at this slide. I just summarized those China's mission in the climate change case, which is the longest submission China has made before the ICJ. And there's various points of divergence point and between the China's opinion and the court's opinion, which I already marked in red and yellow. Maybe later we can see better. And for example, China is very much put emphasis on the sustainable development principle and the common but differentiated responsibilities, and especially the obligations on developed states. And also, for example, following its China's submission before the ICLO's advisory opinions, China was also very much against the identification of greenhouse emissions as marine pollution because this entailing relevant obligations under the UNCLOS. And also we can see from Judge Shi's separate opinion that actually her opinion is very much aligned with China's position, as already outlined in blue, and for example, puts emphasis on the sustainable development principle and the CBDR principles, and also favor the developing states' position. Now let's look at this, turn to the second mode of indirect involvement, which is by the judicial representation. Here, I just draw some about how the judges were elected. And according to Article 4 of the ICJ statute, judges are elected by both the General Assembly and the Security Council. And from a list of candidates nominated by the national groups of the PCA. And actually, according to the two Hague's conventions, member states of PCA can nominate members of the PCA, and those individuals, maximum to 4 persons, consist of a national group. And this national group, actually, their most important function is to nominate candidates for the ICJ. And then those candidates must obtain the absolute majority vote of the General Assembly and the Security Council. So during this whole process, select whom, nominate whom, and vote for whom is definitely not purely decided by the legal criteria, such as Article 219 of the ICJ statute. And it's very much subject to states' preference, I would say, or interference. For example, we can tell from this charter, for example, first of all, of course, the national group's composition varies by national traditions, and the states have a decision on this, of course. And also, if we look at the figures of those candidates nominated by national groups, there is a very much declining number. And during the whole process of election, actually, throughout my research and also other people's research, I find out that those extra legal factors are very much to influence this election process, including candidates' ideological affiliation, educational background, even personal capacity or temperament, and the political bargaining plays a very important role in this whole process. And state support in election actually is a very indispensable condition or very necessary condition for a very qualified candidate to be elected. And on the bench of ICJ, there was a pattern that there always a seat for a permanent 5. But as we can tell from these charters, since the 2017, UK lost its seat in the ICJ. And there's a memorandum issued by the Foreign Commonwealth Office. And in this memorandum, UK just listed those efforts it's made for about the lobbying campaign. For example, as I remarked here, made targeted lobbying of states known to be less favorable towards the candidates through bilateral and multilateral meetings and courts and held events in The Hague with the candidates. And although in China's case, there were no official record about this lobbying campaign, but through my informal conversations with my colleagues and friends who work in the China's Ministry of Foreign Affairs, the same kind of work definitely was taken by Chinese government to assure its candidate can be elected smoothly. So therefore, put my findings into almost logical and mathematical terms. P1 refers to qualification of the candidates. P2 is states effective lobbying campaign, and P1 is a necessary but not a sufficient condition for Q. And if once a candidate is elected, you can presume P1 to have the qualifications as provided by Article 2 of the ICJ statutes. But also, I would say the absence of lobbying does not mean that a candidate will not be elected. This reflects Article 9 of the statute, and because it requires diversity and representation on the bench. But in most cases, P1 combined P2, this condition will lead to Q, a candidate to be elected. And at least until 2017, a candidate from Permanent 5 is equal, like almost, because it's combined these two conditions, P1 and P2, guarantee the candidate will be elected. So right now, let's move on to the Chinese judges on the bench. Actually, last I like to say is Chinese judge bias. Let's find out. And so here, I just according to my own counting, which could subject to omission, there's almost 40 individual opinions issued by 3 Chinese judges on the bench. And of course, Judge Shi Hanqing is the most active one. And here, my presumption is that a national judge's opinion will reflect or align with the position of their home state, especially in China's case. And here, as Judge Donohoe once observed, nationality has shaped the way we think because of the schooling we have, the kind of legal training we have. Certainly, our perspectives on issues are influenced by our nationality. So let's first look at Judge Shiyue Lu's I will most focus on dissenting opinions because this shows very strongly their positions. And judges have sitted on the court for almost 16 years, but there was just 4 opinions, dissenting opinions, mainly focused on this legality of use of force, just these 4. And let's skip in all those details of his legal reasoning. And I was really could not help wondering that his dissenting opinions should be taken understood under the political context because US-led NATO fired the Chinese embassy in Belgrade just after the cases was fired by Yugoslavia and before the issuance of these orders of the court. Yes, it's finished very soon already. Then right now, let's take a very quick look at Judge Shi's dissenting opinions. I would say not biased, but definitely her dissenting opinions as qualified judge is very well elaborated. And also some parts are her opinion also gained the support of other colleagues. But if we look at those main points she made, she put a very much emphasis while her dissenting is very much about the judicial overreach and about jurisdictional issues. That is very China's concern also. Then in the last page, pre-last page, let's just take a very quick look at the judge's profile because it combines perfectly the Chinese ideological roots, Western legal training, and most important is the diplomatic career, because in China, you must enter this Ministry of Foreign Affairs, which require very much you have, besides your qualification, the ideological affiliation is very important. And also she have a very much visibility in the international bodies. And also like she gained the support before the regular election, because she was elected by the by-election after Judge Shiyue's resignation. And her opinions is advisor opinions in the advisor opinions extended or aligned with China's position, and her dissenting opinions is very much about the judicial overreach. So turn to the concluding point. I may not repeat all those points I already like addressed throughout my presentations, and I draw a quick conclusion potentially could be applied to other great powers, that great powers tend to exercise their influences through by indirect modes and trying to shape or monitor the international legal discourse, but without dominating it. Thank you very much.
Thank you very much. I feel like there are a couple of papers in some of these presentations and a lot to discuss, hopefully, during the discussion. Last speaker is Bianca Ortiz, who has just concluded her judicial fellowship at the ICJ, so she's coming from the heart of the action. At the court, she assisted Judge Charlesworth. She's now starting her MPhil in law at the University of Oxford, and she'll be talking to us about her MPhil topic, judicial avoidance at the ICJ.
Great. Thank you for that introduction, Asli, and thank you to James and the organizers for inviting me to this conference. So as Asli has mentioned, I'm very excited about presenting on this topic because it's the topic of my incoming thesis at the University of Oxford. That said, it goes without saying that what I will share today represents a very early stage of this work, and it's very much a work in progress. So everything is caveated that it's not yet the ultimate conclusion, and everything is pretty much pending. So without further ado, over the past century, there has been a multiplication of international courts and tribunals. With this came what Karen Alter and others call the judicialization of international relations, or the increased involvement of international adjudication in the realm of international politics. Occasionally, this judicialization brings cases involving what scholars call high politics or megapolitics before international courts and tribunals. So the ICJ has long been at the center of this activity. On one hand, it presents itself as a court of law that does not shy away from politically sensitive disputes. On the other hand, its practice reveals more nuance. Formally, the court has not recognized a political question or justiciability doctrine. It has said repeatedly that the fact that a dispute is politically sensitive does not deprive it of its legal character. And the court has made this point explicitly, for example, in the Tehran hostages case and in Nicaragua versus the US. The same is true for advisory opinion proceedings, as the ICJ has stated explicitly in the nuclear weapons advisory opinion. So despite this, the ICJ has, in some instances, chosen not to decide issues that fall within the realm of high politics. The most often cited examples came from the court's handling of the nuclear weapons disputes. So the first set of cases are the nuclear test cases brought in 1973 by Australia and New Zealand against France, challenging the French atmospheric nuclear tests in the South Pacific. So eventually, the court did not rule on the legality of the French nuclear tests. Instead, it held that the applications were without object because France has made unilateral declarations that it would stop the testing. Adopting a narrow characterization of the dispute, The court reasoned that because of these declarations, the objectives of Australia and New Zealand had been achieved. The second set of disputes involves the cases brought by the Marshall Islands against the UK, India, and Pakistan, arguing that these states had failed to comply with their obligation to negotiate nuclear disarmament. Once again, the court declined to reach the merits. This time, it introduced a novel awareness requirement where the ICJ stated that the respondent should be aware or could not have been unaware that its views were positively opposed by the applicant. On this basis, the court held that no dispute existed and therefore could not proceed on the merits. In all these cases, the court decided not to decide on the merits, and both sets of judgments drew sharp criticism. Commentators questioned the doctrinal soundness of the court's reasoning, and some argued that the ICJ invoked procedural obstacles as a pretext to escape politically no-win situations. So this brings me to the central concept of the presentation, which is judicial avoidance. For today's purposes, I define judicial avoidance as the deliberate use of procedural or interpretative techniques by an international court to refrain from adjudicating or to narrow the scope of adjudication of disputes that are politically sensitive. To this, I will add that it is not compelled by strict legal necessity. Rather, it reflects a strategic choice aimed at preserving the court's authority, legitimacy, and long-term effectiveness in a system that depends on state consent and cooperation. So how does judicial avoidance manifest? Judicial avoidance may manifest through the use of avoidance techniques, or, as I define it for today, procedural or interpretative devices employed by international courts to dispose of, deflect, or narrow disputes in ways that prevent engagement with their most politically sensitive aspects. So the literature actually offers several classifications of these techniques. For example, Felix Bouchard in 2020 proposed two categories in the context of the ICJ. The first is merits avoidance techniques, or techniques such as denial of jurisdiction, standing, and the non-existence of a dispute. And the second classification is issue avoidance techniques, such as the restriction of the scope of review, practicing economy of argument, and the finding of non-liquid. So how has the ICJ applied these techniques? We have already discussed nuclear weapons disputes. Let me briefly note another example from the advisory function of the court. In the Kosovo advisory opinion, the court was asked whether the unilateral declaration of independence by the provisional institutions of self-government of Kosovo is in accordance with international law. The court interpreted the question very narrowly. In its interpretation, it asked only whether the declaration as an act by a non-state actor violated international law. On that narrow point, it held that there was no applicable prohibition. This despite the court boldly saying that it is not concerned with the political motives behind the request or the political implications which its opinion may have. Scholars didn't hesitate to point out that the court failed to engage with the issue of the lawfulness of the secession as such, nor of the broader issue of self-determination. For example, Timothy Waters called the advisory opinion as a masterpiece of avoidance, and John Cerrone a non-opinion. So an obvious question arises, how do we distinguish judicial avoidance from the legitimate or ordinary application of procedural rules? So to help answer this, I propose several criteria that may serve as indicators of avoidance. So first is conventional or doctrinal integrity. So it could be argued that when a court is practicing judicial avoidance, the court introduces novel or stretched interpretations of procedural rules and tests, creating obstacles that are not firmly grounded in prior law. An example could be the Marshall Islands ruling, where the court created this new awareness requirement for the existence of a dispute, arguably not clearly grounded in the rules or in prior ICJ case law. The second indication could be consistency of its application across cases. So its application across cases, despite their political salience or their political sensitivity. So if there's a manifestation of judicial avoidance, the court expands or innovates standards in politically sensitive cases, but does not apply the same standard to non-politically sensitive disputes. The third is impact on substantial justice. So the effect of avoidance is to sidestep the highly sensitive political controversies while leaving the dispute or the key issues largely unresolved. So, for example, in the Kosovo advisory opinion, it left unresolved the legality of the secession, sidestepping the main substantial controversy. The fourth indicator could be the amount or the degree of the political sensitivity of the issue involved or the issue before the court. So the degree of political sensitivity can determine the likelihood that the court or the tribunal practiced avoidance. And lastly is the anticipated risk of backlash. So in this case of judicial avoidance, self-restraint is applied primarily in cases where there is non-compliance risk, pushback, and great power politics, and where potential institutional harm could be involved. For example, in the Marshall Islands case, the respondents were nuclear armed powers, and avoidance arguably motivated by the risk of non-compliance with the judgments. So depending on the degree of the presence of these indicators, it can be inferred that the court is engaging in avoidance rather than simply applying ordinary procedure. So the next question to ask is, why would courts practice avoidance? So Jed Odermatt distinguishes between principled and pragmatic grounds. So principled grounds relate to the court's structural role. It ensures that it does not exceed its judicial function. And pragmatic grounds involve preserving legitimacy, authority, and long-term effectiveness. According to one view, the ICJ exercises avoidance as a covert political question or non-justiciability doctrine. So in this vein, Anna John argues that some disputes are de facto non-justiciable, and that the response of the ICJ to these disputes is to practice judicial avoidance. However, as other scholars have emphasized, and I tend to support this theory, is that international courts mainly employ judicial avoidance as a way to preempt and manage backlash. So a distinctive feature of international adjudication in general, and the ICJ adjudication in particular, is that it is heavily dependent and reliant on state cooperation and state consent. So the system requires that states view the proceedings and institutions as legitimate. However, there has been a trend of state resistance to international adjudication. So judicial avoidance in this light can be understood as a form of legal diplomacy or a way for the ICJ to balance its mandate of upholding the rule of law with the need to maintain state cooperation and uphold its legitimacy. This leads me to my final question and some food for thought. So is judicial avoidance justified, or should judicial avoidance be avoided? So on one hand, avoidance may look like abdication. In the cases mentioned, the scholars have argued that it undermines the ICJ's mandate to uphold the rule of law, produces incoherent doctrines, and projects weaknesses. It also leaves pressing questions of international law unresolved. On the other hand, avoidance may be the strategy that allows the court to survive in a fragile and politicized system. It can protect institutional legitimacy even at the cost of substantive justice. So whether this trade-off is acceptable remains an open question, and this is actually something that I hope to answer in my thesis. So to conclude, the ICJ is often faced with disputes involving high politics and megapolitics, but it has no formal political question or justiciability doctrine. However, in practice, it has developed a repertoire of avoidance techniques. These techniques, ranging from merits avoidance to issue avoidance, allows the court to navigate highly political and controversial disputes. The drivers of avoidance lies in the court's dependence on state consent and cooperation and the risk of backlash and pushback from states. The ultimate question is normative. Is avoidance a necessary evil of international adjudication or an abdication that should itself be avoided? So thank you so much for listening, and I look forward to your questions and for the engagement that follows. Thank you.
Yeah. Thank you, Bianca. This leaves us with about 45 minutes before the lunch break for questions and discussion. Do we need this microphone for the audience? For the panel. Okay. Yes, please.
Do I need a microphone or should I shout?
Ideally for online.
Right, I don't have to shout then. Well, thank you very much for all 4 very interesting speeches, and apologies to Alison for avoiding her lecture while dealing with my emails. Really just 2 quick comments on the last speaker, Bianca. I think it'll be very interesting to read your eventual thesis, but 2 points about it. Firstly, I noted you did avoid answering the question about whether avoidance is a good thing or a bad thing, and perhaps you will avoid that even in your final thesis, because it depends. It all depends on the case, I suspect. 2 points. You seem to assume that you know the reasons why the judges do things. And I remember Judge Abraham being very categorical in the International Law Commission when he addressed them, saying, you cannot tell why the judges do things. You can only read the judgment. You cannot speculate about what's behind it. Of course, writers do tend to speculate, but you have to be very careful speculating, I think. So I think perhaps you need to explain how it is that you can imply motives to judges collectively or to individual judges. The second question perhaps is you didn't answer at the end, but you seem to be assuming that avoidance is a bad thing. I'm not sure that avoidance is a bad thing. Judges and the court should answer the question. They don't have to answer more than the question. They don't have to answer questions that writers find interesting. It's probably a very good thing not to answer everything, and I wouldn't call it avoidance necessarily. It's to their credit that they answer the question, but without or don't answer the question where there's no jurisdiction or where it's inappropriate. So that just if I may, very quickly on the other 3 speakers, I think they were all rather harsh on the objects of their discussion. I think Andreas, for example, was rather harsh on Russia. Now, despite what Russia has done, which is no doubt terrible, I don't think you were really putting forward a glass half full. You were putting forward a glass that's overfull, and a glass that's overfull is a dangerous glass, as we all know from experience. But I think that the court, in the case you focused on mostly, the Ukraine-Russia provisional measures case, the court really went very far. Firstly, it gave a provisional measure of extraordinary breadth that even Ukraine hadn't asked for. And secondly, it gave it under circumstances in which jurisdiction was very dubious indeed, given the curious nature of the case that Ukraine and its lawyers had seen fit to bring. So I think the reaction of Russia was not all that surprising. And I could see other governments taking a very similar approach in such in similar circumstances, if such an unreasonable decision, well, I mustn't be harsh on the court, but if a decision of that nature had been made. Now, Walter, I think that you're harsh on Latin America, because what Latin American politicians do is being done all the time around the world, and British politicians, when they talk about judgments of the European Court of Human Rights, for example, and apparently, unfortunately, politicians of all parties here say things that are as wild, to my mind, as those that are being said in Latin America. So I thought you were a bit harsh on the region. And I think you're also a bit dogmatic about territorial about the idea that they're not really trying to solve problems. A particularly good example, though it's not Latin, is Guatemala-Belize, which I won't say much about because I'm involved in it. But there, it's a genuine wish on both sides to solve the problem, even so far as going for the very first time, I think, to a referendum in both parties saying, do you want to put this to the court and solve this problem? And the answer was a resounding yes in one case and just a yes in the other case. But anyway, it was a yes. And so this is very much with a view to solving the issue. And then Shiyue, very interesting indeed, and I'd be very interested to know why Judge Shiyue has changed her mind on this very important matter of erga omnes, jurisdiction over erga omnes in erga omnes cases. She was very firm in Belgium, Senegal, the first time it really arose, that this is a bad thing, it's subject to endless problems, and she maintained that with strength, and I agreed with every word she said, every time she said it. And then suddenly, when a case involves Israel, she takes exactly the opposite case, without any explanation, other than, I think, if I'm right, she said something like, this is a different case, which I sympathize, that's a very good legal argument. But it's very interesting. So I think that, and I just say one thing, that China's participation in cases is nowadays very impressive. I think their contributions, especially in the written and oral pleadings and the advisory opinions, have been very good, very constructive on the whole, and I might also say very well written. They write in very good English. It really is excellent the way China is currently beginning to play a full part in case at the ICJ, but I've spoken too long. Thank you.
Thank you very much. Well, this was a set of questions. We can maybe still take another question for the first round, please. Yeah.
Well, thank you. Okay, my name is Muller. I'm with Maastricht University. I just wanted to, I also want to thank all the speakers for excellent presentations. Unfortunately, I only have questions or comments for two. For Lucia and for Bianca, but just actually, it also ties in with the previous speaker because I found your presentation very interesting. I also had the impression that you were still kind of looking into different methodologies to see what the best lens of analysis is for you. And so I just had a few suggestions that you can either ignore or take into account. Because I think that one important part and one thing that sets China apart from other great powers is, of course, it has a separate history as a relative outsider. And well, as this also appears from the previous speaker, it has basically been increasing its skills over the last decades. And now actually, China has many very formidable international lawyers, and it's reflected in the quality of its submissions and their academic work. But at the same time, the political perception, and that actually does tie in with what Walter said, is that there was a mirror image, especially during the South China Sea case, where China didn't want to participate because the perception was actually, oh no, all those international judges are biased against China. So it's not, is the Chinese judge biased, but are all other judges biased against China? And I don't yeah, I don't know to what extent you take this kind of history into account. But I was also wondering whether you are going to compare also the Chinese ICJ judges with maybe Chinese international judges in other tribunals, taking into account the differences, of course, between the ICJs and institution and the other ones. Because I do think that the ICJ judges tend to have taken substantive positions which are more closely aligned with the Chinese government positions, while in other courts they appear to feel freer to take other positions or to divert a little bit. And but I realize it's also quite a risky one. But with Judge, it might also be a matter of her personality, because she's a formidable lawyer. But I have never, I think, even among Chinese international lawyers, met anyone whose personal views seem to be so much aligned with those of the government. And so I don't know if that's yeah. But the other thing is that, well, by focusing only on the ICJ, you might also risk, engaging a bit of circular reasoning by, basically explaining that things are the way that they are because of the way that they've behaved. So expanding it might be a good way to look at it. And I think that's the main, the biggest challenge would probably be that China has this consistent position of avoiding third-party dispute settlement, making reservations to compromissory clauses, and are you going to address this issue as well and see if there are ways to escape from that? But my second question is just for Bianca, but it's a bit of a frivolous one. But you identify another criteria for avoidance. Do you think that they could also be used to identify maybe when a court wants to be more activist, so that you can kind of flip them around or mirror them in a way when it seems that the court is too eager maybe to take up a case rather than trying to avoid it for all kinds of different reasons. So thank you.
Thank you very much. Shall we start with Andreas and go in the order of presentations?
Yeah, thank you very much. Is the glass over full? Well, I mean, I would have a slightly more positive view on the court's take on this case. I think the clause in Article 9 of the Genocide Convention is quite wide. So you could view it as a question of interpretation, application of the convention that was submitted to it. However, I would say that was at least not the main focus that interested me in my presentation, because you said, well, Russia maybe had a good reason not to follow suit. What I wanted to look at was actually rather what did it mean for third parties? So how did it motivate for third parties? Because I think, I mean, I'm now just going into a very not very solid ground, but I would say I would make a wager that Russia might have not followed suit in any case with an order of the ICJ in that particular case. So I would say the question is more, what I find more interesting in that particular issue is, what can it mean for third states? And that is what I wanted to explore in that respect. Of course, there is a question that is attached to it, is how good is the argumentation actually by the court? How much solid ground is it? But I mean, what I wanted to emphasize here is that I found it, particularly looking at it from the perspective of my home country, Germany, I found it quite interesting how much the debate has changed. Right? I mean, if you think of when Ukraine made the application, Germany wanted to sell helmets to the Ukraine, right? I mean, that is where Germany was at the time. And of course, that has changed considerably. And of course, has it changed because of the ICJ order? Probably not the most important aspect, but I think it is an aspect that an important international institution makes that kind of clear, and by 13-2 majority order. So I think that is something important to take into account, I would venture. If I may just make a very brief comment on Bianca's presentation, following also what Sir Michael said, is I would very much second that I think one should view it also as a positive technique, right? Courts are also, of course not exclusively, but are also political actors, and particularly the ICJ, right, which is principal organ of the United Nations. So has a political relationship to the other organs and of course also to the member states, right? And some questions in a particular situation and at a particular point in time might be actually quite unfair to submit to the court. I would say the nuclear weapons advisory opinion, that was a very unfair question for the court to ask, right? And it probably gave the only answer that it could actually give, because the two other alternatives would have been really problematic in either respect. In the one respect, basically saying you can actually use nuclear weapons at some point. Yeah, that's permitted under international, very problematic. But also, it would really gone into an enormous backlash right after the end of the Cold War in confrontation with the nuclear power states to say, well, it is actually illegal. Yeah? So I think there is some positive aspect also to it, that the court sometimes might be asked questions that it actually should avoid asking, yeah, in the particular situation. I mean, might be a different situation now. Yeah? Be an interesting question. What about the climate change advisory opinion had it been asked in the 1980s? Yeah. So I think it depends on the time, it depends on the political situation, and what kind of situation the court finds itself in, I find.
Thank you, Sir Michael Wood, for your comments. I think you really made a very interesting roundup of all the things we discussed. I think that the first thing I can say is that you just gave me a research idea because when you mentioned the Guatemala Lice case, I think that the most important thing that I can think right now is this distinction of how those states behave when they are in front of a compromise instead of their usual litigation around the Pact of Bogota, which probably has become undesired scenario, which leads to these effects of backlash and effects of resistance. And I think absolutely agree with you that the behavior of those two states regarding the compromise is exemplary. And the research idea could be comparing the effects of this very well done, very politically sound compromise with the situation of Venezuela and Guyana, which is, despite being a compromise, a situation that has really deteriorated legally and also politically. And it's very strange because it's a compromise when you see even the idea of non-appearance, as Venezuela is rejecting the jurisdiction that it had agreed. We all know, certainly all of you are familiar with this issue regarding who is the one that should have decided the compromise, how the Secretary General sends the case to the ICJ, and this becomes a point of controversy between those countries. So I think that with that decision, I would really follow that line and make a research, because I agree with you. The point you made to the presentation of Bianca, I think that there is also a reflection of a Latin American case that is very relevant. You suggest that avoidance can be useful, and avoidance can be also sometimes strategically a good idea. Bianca, there is a part in the Colombia-Nicaragua litigation when I think that your notion of issue avoidance appears and is perfect, and you could really work on that. And it's in the point where Nicaragua was claiming the Colombian islands in the Caribbean. At some point, the first and the original claim from Nicaragua was, I want all the islands. I want not only the big islands, but also the keys and all the maritime formations. When the court started to validate the Colombian position that the sovereign effectivities, the court validated that and said, Colombia has done the effectivities, they are Colombian. Nicaragua changed the position, and Nicaragua said, okay, if they're not going to be mine, they are not islands at all. They are not only not mine, but I don't want them to be islands. And Nicaragua proposed an idea that since many of those formations were coralline formations, they shouldn't be considered islands, and if they're not islands, they cannot be Colombian sovereign property. The court did absolutely, in one paragraph, issue avoidance. The court said, this was not your original question. This was not something that you proposed, and you're changing your position. I'm not going to entertain this idea. And I don't care if the islands are made of grass, made of terrain, made of lava, or made of coralline formations. A dead animal is a coralline formation. I'm just going to adjudicate that those are islands and are colonial. I think that shows that in your framework that you're creating, maybe sometimes is the plaintiff, if the applicant is the one that pushes the court to do avoidance. Avoidance is not only a behavior that the court has in its own mind that it does willfully. Maybe sometimes it's the actors that push them to avoidance, and that will be very interesting to recollect. I'm sorry to make this reference. I am a lawyer from Colombia, where I was I was trained in the United States, and they present Marbury versus Madison as a case of judicial avoidance. They say the creation for judicial avoidance was the idea that this judge, Marshall, cannot entertain the request of the plaintiff. So he created a whole idea about judicial review that was based on avoidance. So maybe sometimes avoidance, I agree, we want a piece of the case because of that. Maybe avoidance is good. So thank you.
Okay, thanks very much for the comments and the questions. First, I would say to Sir Michael Wood about your comment on China's progressing in the written submissions. I would say, as a Chinese, I'm happy to hear that, and thank you for the acknowledgement. As for the position changing in Judge Shi's opinion in either those contentious cases, or actually in my research, before I started this chapter research, I thought would gonna be a very super short chapter because China did not participate in any case before the ICJ. Then, as long as I decided included the part of judicial representation into this representation, this presentation or this research, it turns out a huge amount of work because we saw that China did not participate so much, or Chinese judge do not, but actually Chinese judge do have a lot of opinions. And actually what I examined in my research is just on the dissenting opinions. And also among those advisor opinions, I just examined those cases where China also participated. So I did not look through all those opinions, including declarations or separate opinions of judges. So I could not I did not read others. I don't know what is the exactly point about her changing position. And regarding to your questions or your comments, I find it very, very interesting because a lot of them actually touch upon all those points I have done in my doctoral research project. And I would respond point by point. And first, about the South China Sea arbitration case, I think it is a very quintessential case. As I said, it's about the second. I think the second subcategory I said about non-appearance. I also find very interesting today on the panel have a colleague from the Philippines. And I think in that case, I did also another presentation last year in Tromsø in the Norwegian Center for the Law of Sea. Exactly, I was examining this case. And I was talking about the revisiting the unsettled South China Sea case because and recalibrating settlement pathways amidst legalistic campaigns and political realities. So I think in this case, it's exactly shows to, as we said, smaller states, and also there's a lot of research on smaller states as like a litigation, like a statecraft, how to stand against the great powers, and also the professor already mentioned it's how to. It's also I think you mentioned in your presentation it's about how to leveraging the support from certain parties or states, and in this case I think it is a very legally speaking, it's a big victory for the Philippines, and it is legally speaking, it's a big defeat for China, and it shows exactly how can you leverage legal norms to change the political environment, but also the aftermath of the South China Sea arbitrations. We know China firmly against it, and we can share even this arbitral awards even hardened the position of China in South China Sea. And so we can say this case is for good and for bad, and always we have to find a balance between those legal norms, legal interpretations, which is sometimes very idealistic, and also the political powers. And also, actually, I think this case serve as a kind of motivator for China, as Sir Michael mentioned, China participate more in those proceedings. Actually, this legal defeat really could make China to reflect its long approach of avoidance of international adjudication. And because right now you cannot avoid more, and maybe you better join the party. And also, for example, maybe in other like occasions, like I also did another research on the China's like China's approach on the law of sea, like dispute settlement. Actually, maybe we don't notice that, but actually in there was one case, China participated very shortly in the procedures, the review panels of that convention on the conservation and management of high seas fishery resource in the South Pacific Ocean. And it's a very short-lived participation of China in this quasi international litigation, but later China withdrew the case. This is the only case, as far as I know, China participated. And so I think there is a really changing like a movement from the Chinese government. So, and also about benchmarking Chinese judges on other like international court. I would say yes, I did a research about Chinese judges on the bench of the 8 laws. I would say the situation is a little bit different from the situation of the ICJ, because in the 8 laws, I would not say Chinese judges' position align very much with Chinese positions, and especially China is very against to the advisory jurisdiction of the full courts of the 8 laws. But also, Chinese judge did not say anything in these advisory opinions. And also, I would say this also depends very much in the 8 laws case. I would say depend very much on the judge's own legal training. For example, the current judge, who was an ambassador of the China's Ministry of Foreign Affairs, as far as I know, he did not issue any opinions. But another judge who was a scholar, Judge Gao Zhibo, and he issued more opinions, and they're all very well elaborated and very highly cited in articles of other scholars and those things. And about other judges on the bench, I think there's another one called the Liu Dajun in the ICTY. I did not research yet, and also because China did not participate, it would for me, it's a bit difficult to speculating and how to compare, because in the ICJ case, I have very clear benchmark like China judges and those things. So I would look into it, but I did not. And about the personality of a judge, I think during my research also about what I said about the election and the election process. Actually, there are empirical researches about how, like, for example, USA, why they're against some candidates, why they do not. And one part is a personal temperament. And even during the Cold War and those things, and I think there's very interesting comments said they would against, I don't remember, like a USA would not approve a judge from certain, I think it's a European country where, or Finland or somewhere, or but they would prefer another judge of Germany or somewhere else because they think that the other one has a strong personality, can resist the influence from the others. It is true. So I think Judge Shi is definitely, as far as I heard, it's a very strong personality and also have a strong leadership, which is beneficial for China, could possibly convincing others, or I don't know. And yes, I think that's all I would like to answer. Thank you so much for your questions.
Right, thank you so much, everyone, for the comments and also a few questions. So regarding the first point about, I guess, the normative value of avoidance. So I left the question open, should avoidance be avoided? And I'm glad to see that at least 3 people here, Sir Wood, Walter, and Andreas, think it's one of the two, that it should be justified. But also, I guess it's also worth considering the debate on the other side of the spectrum, that it ultimately contributes to inconsistent decisions. It doesn't resolve the dispute. So it's more of a principled argument, I guess, for avoiding avoidance. But I guess this whole debate is something that's going to be very interesting to research on and will unfold eventually, hopefully within the next year when I do have to pass the thesis. And with that, and I also, regarding Tim's question about judicial activism, it's very interesting that you sort of drew that connection. And this is also sort of connected to Sir Wood's comment on motivation versus behavior. So there's some theories on judicial behavior, such as judicial activism, judicial restraint, judicial caution. And I think part of the research is also finding where judicial avoidance could be in that space. Like, is it on the spectrum of judicial restraint versus judicial activism, or is it outside of that spectrum? Is it about being conservative? Is it just about being strategic? So that's something that's very interesting also that she pointed out. But with regard to the indicators, yeah, it's inevitable that some of the indicators could apply, like how consistent the court is, how supported it is in the past doctrines. So in that regard, it does apply to a few. I think it could also apply to a few indicators of judicial avoidance. And regarding Andreas' comment, like, it's really interesting to see like, or sort of have a thought experiment. Like, what if the court was asked the climate change advisory opinion before, when it wasn't as sort of like secure, I guess, in the international legal order? And to that, it's just ties in with the idea that sometimes the court would be more impelled to exercise avoidance in some climate, depending on the political climate, depending on its political capital in the international legal system. So, for example, before, obviously, at the aftermath of Southwest Africa, for example, it did not exercise judicial avoidance in Nicaragua versus US as a way to sort of regain legitimacy, which is the opposite of what it could have done to preserve its legitimacy. So it also depends on the particular climate, I think. So those were all very interesting points, and thank you so much for the wonderful discussion.
Thank you very much. I think we have time for a second round of shorter questions, shorter answers, if possible. Then I'll please.
Thanks. Nihal Buda, University of Edinburgh. So I have to say, listening to these four very fascinating presentations, the person I can't get out of my head is Hans Kelsen. Right? So all of you know 1944, Peace Through Law. The basic thesis is we need a world court simply because it's the only possible way in which a political problem can become a legal problem. We must achieve that, even if not every political problem can become a legal problem. To the extent we can do more of that, we have succeeded. So in sort of Kelsen's logic, politics can become law to some degree through the instance of a form of adjudication. And the unarticulated premise would be that once politics becomes law, law generates its own politics of a certain kind. So I think the massive rise in the caseload of the ICJ, the secular trend towards delegation of certain kinds of decision making by states over the last 50, 60 years suggests that the first premise is right. I guess the puzzle for me is the second premise. What exactly is the politics of law? I think it goes to your point, Andreas, and I think in many ways touches on Bianca's argument, also Walter, which is, Kelsen, bless him, was heavily influenced by his PhD dissertation, which was about Dante, which implied or involved a kind of strong commitment to a kind of philosophy of history that assumed that once you travel down the path, once politics becomes law, it doesn't become unlaw. And I think the puzzle of the present is actually that's exactly what we're witnessing in various kinds of ways. And I guess the interesting question for me is, maybe from Bianca's perspective, is that an argument for avoidance or is that an argument for doubling down and trying to persist? No, actually, we want more law, not cooperation in the process of unlaw. And I think it's an open question. I just one point to Bianca, just for our own reflection. I mean, the difference between the 1996 advisory opinion on nuclear weapons in style, in reach, in argumentation, in the use of sources, and the climate change opinion is, it's not even chalk and cheese. I don't know how incomparable it is. So this is the opposite of avoidance, as far as I can tell. Is this, in your assessment, good or a bad thing?
Thank you. Thank you. My name is Karel Wellens from the University of Nijmegen in the Netherlands. I shall be very brief. First of all, I think it's important that it's impossible to overemphasize the importance for commentators from whatever perspective to the International Court of Justice that we should, as Michael said, not speculate about what was in the mind of judges. Only the text of the judgment and the opinions matter. And I would like to come back briefly about provisional measures. Andreas has been speaking about it, and Alison as well. Now, there has been lonely voices within the court to say that non-compliance with provisional measures should be dealt with immediately and not waiting for the merits judgment, to wait for any kind of pronouncement by the court. States are obliged to report on compliance with provisional measures. On the other hand, there is their obligation not to aggravate the dispute pending the case before the court. So I was just wondering whether there shouldn't be any kind of procedural mechanism, not to wait for a couple of years before the marriage judgment in order to deal with non-compliance, because the system like it works nowadays risks to downgrade the binding force of provisional measures. Thank you.
Thank you, Christian, please.
Thank you, Christian Tams, Glasgow. I have two questions that reflect curiosities. For Bianca, I was intrigued by your 5 indicators of avoidance, consistency, integrity, impact on justice, sensitivity. And I look forward to seeing what you come up with. And I hope you're not worried by the Abraham impulse and that you do check. Because, I mean, if we just go with what the judges say, I mean, it's so boring. But how will you do it? I'm curious, genuinely, will this be interviews? Will this be sort of, will you speak to insiders? Because, I mean, there's far more than the text of a judgment, but it's normally so difficult to get hold of it. And of course, there's also the cheap camouflage tactic that you say, of course, maybe this was fear of backlash, but you call it consistency. So how do you call out the sort of the cheap camouflage tactic? Walter, more briefly, Hotel California, cases going to the court, but never really sort of settling. You check out, but you never leave. One point we take from recourse to sort of seeing courts as actors in a longer process is that they never solve things, but they change the rules of the game and the rules of the next negotiation round. And I was curious whether in your experience there's evidence from Nicaragua, Colombia, that, well, yes, it goes on, but it goes on differently. So the next round is shaped by what the court has said. Thank you.
Martina,
Martina Papadaki from the University of Glasgow. Thank you all for your interventions. It was very interesting. So hopefully a brief question and a remark. So the question is to Bianca, and I know that your research is, in its beginning, but have you thought about comparing to different kinds of judgments and whether avoidance changes? Is it different in the context of advisory opinions and contentious cases? Because you mentioned the nuclear weapon advisory and the Kosovo advisory, and there you have the court being able to reframe the question, and then you go to the criterion of awareness and dispute in the Marshall Islands, and is that different? And then that kind of relates also to a broader comment as to whether we can draw conclusions that are kind of broader, and this relates also to Walter's statement about, for example, the Oedipusidetis principle, because in the Burkina Faso Mali, the court did not need to refer to the Oedipusidetis juris principle because there was a compromise and the state actually had agreed to the principle of the intangibility of frontiers. So there was no need for the court to go into this, wide-ranging explanation of the general principle relating to that. So then that also ties to Bianca's statement. Is that avoidance? Is there activism? Why is the court choosing to go beyond what's needed in this case? So these nuanced kind of approaches in every judgment and different types of cases are difficult to assess and provide a framework for.
Thank you. Any other questions? Eleni and Mohammed.
Hi, thank you so much for this. I have two questions for Walter that tag on Martina's last question, which is I found the reference of a love letter to Latin America with Otis Postetes Juris very intriguing. But I was wondering, this is a principle that has been kind of contested as to whether it applies to other regions. And in fact, in the declaration of Judge Yusuf in Gabon and Equatorial Guinea, he actually goes back to this and says, well, this is something that African states never signed on to. And so I was whether you have any thoughts on this or whether you've thought about this kind of like tension. And then the other question is, when you were talking in the first part of your paper about the contribution of Latin American states and their appearance before the court to international law, kind of reminded me this kind of like longer history of this idea of an American international law that we saw coming up in the early opinions of judges at the ICJ. And I was wondering whether you're taking a longer historical perspective on this concept of a particular regional approach that is not just a regional approach, but has something else to offer to the international system as a whole. Thank you.
Mohammed.
So Mohammed Janabi from Glasgow. My question to Andreas is a shorter question. See the four models of impact you are suggesting and to explore the impact of the ICJ judgment. So this kind of combination of both non-compliance and powerful states. So the condition that should be non-compliance and powerful states. My question whether there is non-compliance from non-powerful states, and if there is compliance from powerful states, how these four models will work then. Thanks.
Thank you. Any other final questions? And can I just add one question of my own for Walter? We've been talking about the ICJ, but your presentation made me think about other courts, constitutional courts, because you mentioned the constitutional amendments, I think in Nicaragua and Honduras. I was just wondering, this is my lack of knowledge, but were those amendments reviewed by the constitutional courts in the respective countries, and have the courts emerged as important actors in the relationship between the Latin American states and the court? And do they side with their governments, or do they side, with their judicial peers at the ICJ? We can maybe again start with Andreas, but this time I'll give you 2 minutes each, and you can be selective about which questions you want to reply to, given the number of questions.
Thank you. Okay. Thank you very much for all the fascinating questions. I try to be very brief, so I take Mohammed's question first. I would say my model, I have to think a little bit more about it, but I was thinking of it as applying across the board, just looking at what really is the minimum that remains, right? So in case of non-compliance of non-powerful states, of course, there are other enforcement mechanisms that might be a little bit stronger, right? But still, those four effects that I tried to describe are still at play, right? And of course, if we have compliance by powerful states, we don't have that much of a problem, but still, of course, it feeds back into the normalizing, stabilizing, anchoring, and so on. Right? Then just leaves me 1 minute to answer what is the politics of international law. Very small question. I would maybe just briefly circle back to what I said before in relation to, because you asked in relation to Kelsen and of course the role of courts, and emphasize that I genuinely believe that courts generally and international courts in particular are political actors and have to take this role seriously, right? So I think at some point there is even an obligation to take the political environment into account when you're interpreting and applying international law. Don't believe, and that's very much in line with Kelsen, that there is a single right answer to an interpretation or an application. Yeah? There might be situations where it's quite obvious and very difficult to answer something else, but in the hard cases situation, I don't believe that. So I think there is I would push it to the point to say that there is even an obligation to take. Well, the question is politics or policy, right? Into account, but I would say even both, because you have to be aware as as an international court, in what kind of environment you're operating. And that goes back to the question that you also asked to Bianca, the question with respect to avoidance. When does it apply? When should it? When should one use it, or should one double down on it? And again, I would say it really much depends on the situation that the court finds itself in, and within the realms of methodology. Within the realms of methodology, the court has an obligation to take that the political situation, the political aspects also into account.
Thank you. Well, 2 minutes. I'm going to answer backwards in the way that you presented the questions. First, regarding the constitutional courts and these modifications of the constitutions to entertain or not certain ICJ cases. Regarding constitutional courts, the most grievous example is the one of the Colombian Constitutional Court, which actually Colombia didn't amend the constitution to select or not a winning case. They just said the 2012 case says something different to our Article 101. So several actors of the society actually presented a judicial review action against the Pact of Bogota, saying that the court should tell the presidency not to implement the 2012 ICJ decision. And the court had a different position, and the court said the judgment is valid because it was done under a compulsory clause of competence, but in order to make this judgment legal within the national system, we have to make a treaty with Nicaragua. We have to enforce a treaty. And this just creates a efficiency post-adjudicatory measure that is not common in the system of the ICJ. You cannot say that if you have a judgment but you don't like it, the next step is to make a treaty with your applicant to make it work. So the court actually, as you said, paid with the government to say, okay, I'm going to give you a tool to avoid the judgment, and is that I say that because of the constitution, you need a treaty to implement the judgment. We know that judgments have certain self-executory power, you need to implement it, but it's not that you can make a measure to make a treaty. Regarding the two questions about uti possidetis juris, I think that in the Burkina Faso Mali case, at the end, the court kind of says the principle of the intangibility of boundaries and the uti possidetis juris, for me, in this case, are the same. And they take that position. And I think that when you look at how the court has used them and the system of international law has used them, it has become universalized. I think the best example, with all the political issues, is the example of the Volunteer Commission, the Volunteer Commission for Yugoslavia, when they just copy-pasted and said, we're going to use it, of course. This ethnologically, this culturally is difficult, but it solves the same issue that Simón Bolívar was thinking in the 1800s, is we want to avoid immediate conflict for international and internal boundaries. So I think that has become universalized in that sense. And I think that as well as the idea of compulsory clauses are two of the main contributions of the region to the world regarding international law. We had the first court, the Central American Court of Justice in 1917, which actually exemplified many of the elements that are placed by the Société des Nations in the statute of the Permanent Court of Justice and then in the ICJ. So I think that those are two examples of this contribution. And regarding Christian's question of the Alto California, I think that this Alto California effect as a fear is a fear of the respondent. And I think there are several cases in which the dispute goes differently. I was talking with the delegation of the Bolivia case against Chile, and they say, we lost in the court, but the court in the judgment said that the politicians' statements were unilateral acts. We can grab that from that litigation and continue our diplomatic endeavor to try to achieve the exit to the Pacific. So I think that it's valid that the states do this. They present an application, they grasp what they can use, and further the litigation in another way. In the case of Colombia, it was a little bit different. It was more like this case continues and continues, and we just realized that it's never going to end unless we totally beat our opponent. And that happened finally in the arguments regarding the extended continental shelf. the legal victory was so clear that the state finally said, okay, they cannot go against this. So when you start entertaining the possibility to go to another court and enter another treaty like UNCLOS, this fear of the Alto California effect begins again. Is okay, so now maybe Nicaragua can say, and this is fear. The politicians say, maybe Nicaragua now can say that we're part of UNCLOS, so they can now present an application before ILOS and present the argument in another way. And since this is a new court, there is no res judicata. So are we scared or not? So I think that is case to case the way that you can understand this, but there is a tendency of ongoing litigation that never stops in a final decision. And I think that's partly because of the position of the applicants.
Right, so for maybe I'll tackle 3 points. So first, with Professor Tam's question about methodology, this is a very interesting question. Obviously, if you go up to a judge, he will not say that he was practicing avoidance. It's very much a taboo concept, I guess, in any international court or tribunal. So I think the way to sort of tease it out is that to see these indicators as sort of like circumstantial evidence, not necessarily pointing to motive, but like leaving just an inference that based on these indicators that it is avoidance. And a lot of these indicators could be discerned from external documents that could come out contemporaneous to the dispute. For example, how politically sensitive a dispute is. There would be news articles, for example, explaining what is at stake, what are the likelihood of backlash based on, for example, contemporaneous statements of states participating in the dispute. So I think there are a lot of ways to sort of gather the documents beside from empirical methodology, but obviously it's something I could also consider down the line in case it leads to that. And with regard to Martina's question about comparing the advisory opinion proceedings and disputes, I think that's a very interesting point because in advisory opinions, I think courts have, well, the ICJ has more flexibility when dealing with the issues. And in fact, it has the power to reframe a question or to interpret it in any way it wants. And in that sense, it's sort of different from a dispute where it could potentially be in frapetita based on the application. So I think with regard to that, a technique that the ICJ might have applied is interpretative techniques as opposed to procedural techniques in disputes. So narrow interpretations such as in Kosovo, for example. So that's very interesting point as well. And with regard to Kelson's and Lauterbach's theory on the place of the court, it's very interesting because based on the attitude of the court, it seemed to have assumed this role. Like it says that it could tease out any legal question within a very politically charged dispute. And in fact, it was explicit in saying this, for example, in the nuclear weapons advisory opinion. But I guess what does not sit too well is that in practice, it does something very different. So I think it's that comparison between its stated attitude versus what it might have done in practice that's a bit questionable. So like, how would it be more like useful for the court to for its legitimacy to be more sort of candid about its limitations? For example, the doctrine of a margin of appreciation was used in the ECHR, and different standards of review are being used in the WTO and investment disputes. So, but based on the past cases, it doesn't seem that the ICJ uses such things. For example, it could have done this in oil platforms, but yeah, so I guess it's about the amount of transparency and as opposed to saying something on one hand, but then in practice, not doing the said thing. So that's very interesting to dive into as well. So thank you so much.
Well, thank you, everyone. Thank you for the great presentations and thanks for the many questions. Happy to say that we're breaking for lunch today, which is served outside for the next hour, and we'll meet back in the room at 1:15. Yeah, thank you.